All right, good morning. And I can say that for once because Monica and I are both on the actual same coast of the United States for once. I keep doing these videos with people all over the place. But welcome, everybody. We're talking about Idaho today. And the only person you really need to know for Idaho is definitely Monica. Can you tell us some about yourself? I mean, I can sit here and brag about you, but I have my favorites and you're one of my favorites. So
well, let me introduce myself a little bit. I've been practicing in Idaho for 27 years this year, but my practice in surrogacy has been going on almost 10 now, and it's a great part of my practice just to be able to help people have families. And Idaho has a new law, which we're going to talk about today. So we're pretty excited about that.
Wonderful. Well, and everybody, just so you know, I mean, we go through the states, we go state to state, and we have certain states where we have lots of attorneys doing this area of law. And then we get to certain states where you're just gonna have to know the attorney, the go-to person for that state. Idaho's one of those, right? We don't just have volumes of attorneys doing this area of law. So if you don't know Monica, you're doing any work in Idaho, or you are a family looking at surrogacy in Idaho, Monica's the name to know. So,
well, thank you. Yeah, we are small, and there's not a lot of us who do this.
Yeah, Idaho's like Nevada. There's a lot of rural areas, not a whole lot of cities. Just, some people might think, oh, I'm going to brush off Idaho as a choice, but they shouldn't, right? Idaho, I mean, it is a viable option for reproductive technology and surrogacy.
Yeah, absolutely. It is. In fact, it's been quite a hub for surrogacy. We have a lot of surrogates. We have a very volunteer-oriented culture in Idaho. I think I once heard a statistic about how Idaho has some of the highest volunteerism rates in the country. And so it's a pretty good fit for surrogacy. A lot of people who like to do this, a lot of women who like to help other families. And so, surrogacy, despite us just having a law, surrogacy has been accepted and really friendly in many ways for families for as long as I've practiced here.
Well, I've seen statistics. Idaho's one of the lowest crime rates too.
Yeah.
So, yeah, it's interesting. I hadn't heard the volunteer one. We hear about it in Nevada. We hear about your crime rate being better than ours. So being next door, but I think ours has to do with gaming and a few other things that go on in Nevada. But okay, so the laws changed. So even if somebody's watching this video, if you've watched other videos, because I know Monica's a member of Quad A, like I am, which is the Academy of Adoption and Assisted Reproduction Attorneys. There have been other videos, but things have changed in Idaho. What's the timeline? When did they change, so everybody knows kind of what they should be listening to versus the other videos?
So the law was enacted in April of this year, and it went into effect on July 1st. So we're just about 45 days into the new law. I would note that you can still proceed under the old kind of process because the laws that drove that old process have not changed. But this is really, the new law makes it easier for families and for both parents to be recognized on the birth certificate from the moment of birth. And it takes away some of the antiquated things that were happening prior under the kind of existing framework that was in Idaho that families were using when they had surrogates.
Okay, and because these videos tend to live on into the future, that's 2023. So if anybody's watching this video, I'm wondering, when did you record this, Kim? It was 2023. So, well, in that old method and the new method makes it a little more complicated for us to explain everything to those who are listening, right? So,
right.
Where do you want to start, the new or the old?
Let's start with the new.
Okay.
I think most people will want to be under the new process. I just think it's important for folks to understand that that old process still is available, because there may be times where that is the better option for a family. For instance, if you absolutely need the gestational carrier's name on the birth certificate, which is the case with some of our international countries and clients. And if that's the case, there's a possibility for you to do it under the new law, but the old way is really the cleanest way for you to do that. The other, it would be as if you some reason don't meet the residency requirements and you have a baby in Idaho and you have a surrogate. That's the other kind of where you'll probably be under that old law, at least as things sit today.
Okay,
but let's start with the new.
And that's on the parentage end, but if we're on the contract end, is there really any difference? Is there anything they need to worry about?
No, there is a nuance, and this is a nuance that's important, which is that under the new law, your agreement is not valid and enforceable until you go to the court and have it validated. So if you're intending to be under the new statute, you really do need to take your contract forward and have it validated under the parentage process to be enforceable. And that is a contract issue, right? You want your contract to be valid and enforceable. So if you want to use the new law, you're going to need to be thoughtful about that in your contract process.
Okay. So they've drafted a contract in Idaho. I assume most of the terms of a contract are really not different from other states. So what do they have to do to validate the contract?
So to validate the contract, you need to file a petition with the court. It can be done before birth, which is what most people I think will do because of that valid and enforceable piece. But it has to be done no later than 7 days following a birth. So there's a little bit of window for you to do it post-birth, which is how we've been doing it since the law changed in July for all of our July and August births. But generally you do it before birth, or you do it or before transfer, or after transfer, or 7 days within birth.
Okay, so a lot of time. Does it make the contract phase any more expensive doing that part of it?
No, it doesn't make the contract phase more expensive, but there are some things, there are some statutory requirements to validate your agreement. That's essentially the pre-birth order. And so there are some specifics that need to go in your contract to make sure that you can get it validated.
Okay, good to know. All right, so do they need to know what those specifics are? That's really just too nuanced, and really when they come to you, that's when they'll figure that out.
There's a lot of little requirements like that. And so I would say I don't think it's useful for us to go into all the details. I would highlight a couple of them. And one is that the carrier cannot be on public assistance. And that's a defined term under Idaho statute. And so that's
the statute. Yeah,
it is in the statute. And so that's a pretty important one for folks to understand, that they have to a carrier can't be on public assistance. The rest are a little bit more nuanced and we don't need to have details. But for anybody thinking about Idaho and agencies who might be thinking about surrogates in Idaho, that's an important piece for them to understand.
Yeah, especially in screening surrogates and deciding which ones to move forward with.
Correct.
Sure.
Correct.
Yeah.
Because
okay.
Public assistance is broader than Medicaid, and a lot of states just have a Medicaid requirement. This is broader and it's a very specific. So if anybody has questions about what that public assistance definition is, happy to answer questions, and folks can reach out because it will be very specific inquiry.
As I dropped everything in my office. Okay, so contract, validate the contract. Now we're talking about parentage. So under the new process, well, let me back up for a second. Is there any group of people that need to be worried about moving forward in Idaho? Single individuals, for example?
No, in fact, that was one of the great things about the law, is that it really is open to all people. It's open to single, married individuals, same-sex, heterosexual, regardless of biological connection. So if you have an embryo donor, If you have egg donor, sperm donor, all of those are options for you in Idaho. No limitations, no specific requirements. And so it's very friendly. I mean, if you were unmarried but living together in a domestic partnership, that's fine. So really open to families that way, and you both that are recognized on the birth certificate from the moment of birth.
Excellent. And I know agencies that are listening, that's a big deal for them, right? They've got to decide state by state who they can assist and not.
Right.
So perfect. So now we're moving on. They've got a contract. It's been validated with the court. What's the process now?
So once the birth occurs, we file a notice of birth with the court, and the court will issue an order of parentage, which confirms that the parents are the parents of the child, the intended parents, and that the carrier and her spouse have no rights to the child. And that order of parentage has to be issued within has to be filed within 14 days of birth. And really you need to be filing that sooner because of the process with the hospital. It's kind of the right now in Idaho, a little bit of the trick. In Idaho, the hospitals, of course, like other states, report the births to vital records, and they have a 14-day window to report those births to vital records. And they will only report a gestational surrogacy if they have that order of parentage in hand, along with some paperwork from vital records. And so while the statute allows for 14 days, to make it a smooth process, you got to be filing that notice of birth and seeking that order of parentage from the court really within about 48 hours of the birth.
It's that joke I always tell my clients. I'm like, well, it's one way unless your baby's born on Wednesday at 5 p.m. before Thanksgiving in the United States, right? Because then we can't do anything till Monday because our courts are closed. Yeah.
Right. And it's very similar. So it's not like you can't submit, let's say there's a reason for the delay and you don't submit your notice of birth for 14 days. It's not a problem. It's just that you're going to have to do some extra steps with the court and with vital records because the paperwork wasn't submitted through the hospital. You'll have to submit it directly through vital records.
Yeah. So just not as convenient, but not impossible.
No, not impossible, but important for folks to understand. You have to be prompt with that process, but it is very simple. Notice of birth, order of parentage, submit to the hospital, and then there'll be a birth certificate issued naming the intended parents. The carrier goes, vital records still collects a ton of information from the carrier because it's statistical information about pregnancies, which they collect as part of that's what vital records does. But the carrier is always known on the birth record as a carrier, never as the birth mom or other kind of, nomenclature.
Right. Okay. And does Idaho do parent on the birth certificates, or do they do mother, father?
They do mother, father, or father, father, or mother, mother.
Okay. So not parent. Got it.
Parent.
Okay, great. And then, so, backing up a little bit again too, do you have an actual embryo and egg donation statute now?
We do not.
You're not. So they didn't update that part of it. They got
and
stuff.
They did not. And they did not, the only kind of piece about donor in the statute is that your contract has to talk about whether or not there is a donor and has to have language that the donor did relinquish rights, but there's no specific rules relating to the donor or embryo donation or egg or sperm donation. Idaho does have an artificial insemination statute, and there's donor addressed in that statute like other states, but there is no egg, sperm, or embryo donation statutes in Idaho right now.
Nothing real specific. Okay. And when would you decide to use the old method versus the new method? You touched on it a little bit, but let me couples.
Yeah, let me add just a little bit of context as well. Generally speaking, hearings are not now in Idaho under the new law. You're not generally required to do a hearing. You have to ask the court to waive it. But so far, I have not had the court require us to do any court hearings. And the court hearing would really come at the validation of your agreement, because the parentage at the end is really much more of a administrative. Baby's been born, here's your order of parentage. You've done all the hard lifting when you validate your gestational carrier agreement. So under the old process, though, there is a court hearing. That's what made me think I wanted to tell everybody that is a mandatory part of the old process. So one of the requirements in Idaho is either the intended parents or the carrier have to be residents, and they have to be residents for 6 months to use the statute.
Okay.
So that would be one instance where you we're very close to the border of Oregon. We're close to the border. You know, we've got hospitals and locations and carriers right on the border of Nevada.
Yeah.
And so there may be times when a birth happens in Idaho unexpectedly with a carrier who lives in Oregon, or a carrier who lives in Utah, or who lives in Nevada. And so in those instances, you would have to use the old process to have your agreement validated and essentially use surrogacy in Idaho. The other case would be, as I said earlier, if you're in a country where you need that carrier and her husband to be on the first birth certificate, then the language in the statute is open enough that you might be able to get that to work in Idaho and have the court order a birth certificate with just the carrier first. But the timing issue of how that works and how vital records works means that most likely, if you absolutely need the carrier on the birth certificate, you probably need to do the old process.
Okay. And that residency requirement is probably the big thing to remember, because like you said, we do have towns right on the border, and sometimes it's intentional that they live in Washington, but they want to give birth in Idaho because that's the closer major hospital.
Right.
So they don't have the option of the new method because of the residency problem.
Correct.
Right.
Correct.
Okay. So even if it wasn't an emergency, but you know, they planned on it. The residency part is what restricts that.
Correct. And I think the important thing to know under the old process is it's really a smooth process. But it has some limitations because, of course, the carrier is deemed to be the mother at the time of birth. And so she has to go to court. We have a brief court hearing to terminate her presumed parental rights. She has to sign a consent to terminate in front of the judge. And it's simple, it's easy. No parents have had a problem with it. No carriers have had a problem with it, but it's an extra step that most people don't want to do. But the other piece is that if you don't have a biological connection to the child, you do not go on the birth certificate in the first instance. You have to go home either to your home state or country and have an adoption or a parentage proceeding in that home state or country. Then you can come back and have your birth certificate amended. But it's a little bit more of a stepped process, and it's not quite as friendly to folks who may have to use a egg donor or sperm donor.
So those listening, my Elko, Nevada surrogates, when you're choosing which hospital to go to and it's emergency, you know, sometimes they'll care flight them to Reno, sometimes even University of Utah. But sometimes Twin Falls is where they end up. So we end up dealing with Nevada, Utah, and Idaho a lot because rural Nevada outside of Reno is really rural once we get up in the northern parts. Yeah. Okay.
Yeah. So it's important to understand that if you're both biologically connected, or if you're single, no worries under the old process, but it creates a little bit an extra step when you get home. If you're in one of those boats where you've had to use an egg donor or a sperm donor.
So under the new method, you're going to end up with an order that's issued after the birth of the child, right? So we have a few countries where post-birth orders are important, and they want to see it issued after the birth of the child. So Israel's one of those that I do a lot of work with, and they like to see the surrogate sign off after the birth. Is there anything she signs after the birth for that order?
No, she does.
We could create something for her to sign, I assume.
Correct. And we've had a couple of Israel births in July using the new statute. But essentially, it's a joint petition filed between the carrier and the intended parents. Both parties, I guess I should have said this earlier, both parties have to have independent legal representation through both the contract and the parentage phase. So your attorney has to actually sign the pleading. So you have to have an Idaho attorney for your carrier in Idaho, and you have to have an Idaho attorney for your parents when you file the parentage action. And so in Idaho, what has worked is we do have language in our order of parentage and in the notice of birth that is jointly filed by the parties about the carrier relinquishing all rights. So that has worked for Israel because you have a document that you file that acknowledges kind of a post-birth relinquishment of rights, which is what they require in Israel. And then the order of parentage restates that as well.
Okay. Now, if talking about an Elko surrogate again, and she ends up in Twin Falls, Idaho, not what we planned, not what we expected. If I had already received a Nevada order, how will Idaho deal with that? Do we still need to just go through the Idaho process secondarily?
So the law in Idaho has a great section that gives very blatantly full faith and credit to out-of-state orders. But given the law is new enough, I don't think that has been tested yet. I think an order in Nevada, whether it was pre-birth or post-birth, could be recognized in Idaho. You could not give it to vital records. You'd have to go through a domestication in front of the court to have recognition of that judgment. And I do not believe, even if you got a pre-birth judgment in Nevada or California, you cannot domesticate that until post-birth, based on my conversations with the court, because Idaho is really a post-birth state from an order of parentage perspective. You get a pre-birth and a post-birth, but they're going to rely on the post-birth to issue the birth certificate. So you're not going to be able to really domesticate and use that order from another state until the baby's been born in Idaho.
Right. Okay. And, like in Nevada, for a lot of my couples, I'll get a pre and a post. So if the baby was accidentally born in Idaho, I could get a post-birth order still from Nevada. And for those listening, domestication means we got to basically pay a fee to the court just for them to stamp it, right? In Idaho.
Yeah.
It's always silly when I try to explain it to people. I'm like, well, you're just giving them money so that they'll stamp it there. But that's what domestication means.
Yeah.
In theory, they're reviewing it. If it's completely against their public policy, you may have a problem, I assume.
Yeah, absolutely. Yeah. And that's why prior to this new law, Idaho wouldn't recognize those pre-birth orders from California because they said it was in violation of public policy because of how Idaho at that time recognized birth mothers and fathers and parental rights, et cetera. And so, I think the full faith and credit is a good thing. I think the process to domesticate your judgment will be fairly complicated because of the way recognition and domestication of foreign judgments works. And that's what they'll see this as a foreign judgment. But it can be in concept done.
Okay. So these videos are for some of our attorneys that are, paying attention because they're doing things in Idaho, agencies and parents. So there is a concept called venue. So I'm explaining it a little bit before we go into it. But venue is once you know you're in the proper state and you have jurisdiction in that state, the next question is, what's the proper court? Where in the state should you be filing? So what does venue look like with the new statutes in Idaho?
So venue is not outlined in the statute. It's not specifically dictated. But the Idaho Supreme Court, which has administrative authority over, actions and which judges handle which cases, has issued a statewide directive requiring all surrogacy matters to be filed with one judge. So if the birth is in Eastern Idaho and you file in Eastern Idaho, it automatically gets transferred over to a judge who sits in Ada County, which is where I am in Boise, Idaho, in the 4th Judicial District. So all cases get heard by one judge. There is going to be a second judge who will assist with these now, but it makes it actually quite consistent and it gives you some comfort in how your case will be handled and what's going to be required by the court because it's handled by one judge.
You got some really jealous attorneys listening, I'm sure.
Oh yeah. Mm-hmm.
Because when, for those listening that aren't used to, venue or understanding that, what happens in a lot of the states is you just don't know which judge you're going to get. And it's county by county, and it could be rural counties, and you can have judges that have never seen a surrogacy case before. So Idaho's got a one up on everybody else on that.
Yeah, it makes it very convenient. And again, just really it adds consistency. And it's why under that old process, despite it in some ways not being friendly to certain couples or individuals, it was overall a really easy process because of that consistency. One judge heard all of the cases, and so you had a real clear expectation as to what you would get.
Okay. Now, so once we get the orders, let's talk about a couple of the ancillary issues for Idaho. Is there a passport office in the state of Idaho?
Well, there's a passport office, but you're not going to get a same day passport. You're going to have to go to a big city for a 24-hour, 48-hour turnaround. But yes, we have a passport office, and you can typically get a passport within about 7 days.
Okay. And we talked about how quick, what the timeline was for getting the order afterwards and for the hospital for vital records. But how long does it take them to issue the birth certificate after that?
So once the hospital gets the order of parentage and submits to vital records, we will have a birth certificate anywhere from 7 to 10 business days later. So pre-new law, post-new law, it's really about the same. We see most couples getting a birth certificate anywhere between 2 and 3 weeks after the birth.
Okay. So are they printed? Everything's getting redirected to Boise. So are they being printed in Boise? Is that where people have to pick them up, or
yes,
or have them mailed to them if they're somewhere else in Idaho?
So vital records is very, very particular. There's no ability to go into vital records and talk to someone. There's no counter for you to print anything. There's no counter for you to talk to anyone. They really only work through phone or through email or mail communication. And so we order birth certificates for clients, and then those birth certificates get mailed to my office, and then we FedEx them out to wherever our clients are. So it's not as friendly of a process. Vital records is not for clients. And you do have to have everything. If you want it quickly, you have to do it on an expedited basis. We pay the fees for expedited, but no, there's no guarantee you'll get them in an expedited way. So it's a little bit of a clunky process, for lack of a better word, with vital records. But most they work fairly promptly to get those mailed out, and it is out of Boise. And typically we're getting them 7 to 10 days after the hospital submits the order of parentage.
Okay. And then how are the insurance options looking in Idaho for surrogacy? Always like doomsday question, but
we have continued to see at least 2, if not 3 policies in Idaho that are surrogacy friendly. I think it changes a little bit every year. But generally speaking, we've not had, knock on wood, issues with getting policies. And we have not seen a lot of lien language in Idaho under those insurance policies, which is the other issue.
Yeah, keep it out.
Yeah.
So anybody that's listening, the liens are when the insurance company says, hey, that money that the surrogate's receiving as compensation should really pay us back for the money we put down on the table for insurance, because it was for these intended parents, not for the carrier's own child. Yeah. And so they can be dangerous because you end up paying double compensation in some of those scenarios, especially we have states where we're seeing nonstop lien language all over the place. Yeah. Okay. And then, the other dreaded question is about abortion rights in Idaho, and what do people need to know about that?
So Idaho is not a friendly state for abortion. We have a 6-week, fetal heartbeat type ban in Idaho. There is no exception for if child will be, born without a heart or any of the, won't live, none of that. You really only have an exception for life of the mother. And so it's not a friendly place. But and the language of the statute requires that your contract states that nothing in the contract will interfere with the woman's right to protect her health or the health of the fetus she is carrying. So, we do have language in our contracts that allow the carrier to travel. Boise, I think the positive thing is that we have a lot of locations on our borders where women can go have fetal reduction or termination procedures. Ontario, Oregon is about an hour from Boise. There's a huge Planned Parenthood clinic there. And so, you know, if that is necessary, there are options for women to travel to go have an abortion or a fetal reduction in another state. There's nothing that in Idaho that prohibits a woman from traveling. And there are no penalties there's no aiding and abetting statute the way, for instance, Texas reads. There's some language that's not great, but so far you're really probably not going to be able to do any kind of termination procedure in Idaho, but you can have your surrogate travel out of state as needed to have those procedures.
Okay, so anytime we've got any of these surrogates that are on the border who potentially could give birth in Idaho, it's probably something to really pay attention to. Right, for drafting purposes. Okay, so it's not an impossibility. It's we've got our ways to work with it and keep people safe. And so, okay. All right, so anything major that I've missed as far as Idaho and what you want people to know about it?
No, I think the big ones I wanted to make sure I mentioned were the no public assistance, the residency requirement, and of course, independent legal representation. There is some language about the compensation paid to the surrogate has to be reasonable. So and that's a determination the court has to make, which I think is an easier one to meet because we are in front of one judge. But I would put out that cautionary tale. You are in front of one judge. So if the compensation is out of what is norm for what I see in Idaho, you may have, you know, agencies maybe need to be consulting with me before they're matching.
Right.
To talk about
and as you get more experience with that judge, right? I mean, you don't have a lot of time underneath this judge.
Oh, it's actually the same judge who handled it prior.
The old ones too? Oh,
right.
Okay,
so she's the same judge I've been practicing in front of for nearly
Thank God.
So she actually has a lot of kind of experience in this, you know, even though the law is new for all of us, she has a lot of experience. So I would say agencies, if they have any questions about what I am seeing in terms of normal compensation in Idaho, I would encourage them to reach out prior to matching because they'll want to set those expectations before match as opposed to trying to deal with it post match.
Yeah, that's really important. So agencies, if you're listening, you need to reach out to Monica. I think that's critical. It's good information.
Yeah.
Okay. So anything else that you hit the big topics, right?
I hit the big stuff.
All right. So let's move to how do people get a hold of you? How do they contact you?
So I do have a website, idahofertilitylaw.com. If anyone wants to go visit the website, see a little bit more about myself and my team. I have a fantastic team of people who work with me. And that's a great way to get in touch with me. It has our contact information. You can shoot us a message through the website. You can also reach me at my email address, which is monica@cockerillelaw.com. COCKERILLE law.com. And my telephone is 208-850-3075. And I that's my direct line. Welcome calls, email. Happy to talk to folks about Idaho and what's happening here and help you through any processes that you're considering here in Idaho.
For everybody that's listening, and if you end up with me and you are in northern Nevada, which I consider anything north of Reno, the northern end of Nevada, we're going to end up probably talking about some of these potential repercussions with Monica and what could happen if you end up giving birth there. So, all right. Thank you, Monica. I appreciate you so much. And everybody, we'll be back with more videos. I've got a couple more in the works and we're trying to hit these ones that have new changes that we're trying to get all the information out to everybody. Reach out to Monica if you have any Idaho questions. Thank you.
All right. Thanks, everybody.